Hi, my name's Chad Moody. I'm an attorney here at Hansen May in Boise, Idaho. We have offices here in Boise and in Twin Falls, Idaho. It's no longer a secret that Idaho's a great place to live. There's an extensive amount of construction and volume of home purchases here in the area. This includes both new construction and remodels of existing homes. Inherent in any construction project is the construction professional's concerns and rights to be compensated for the work and the materials they provide. Under Idaho law, there are protections for these types of professionals to secure their right to payment. These typically are in the form of a mechanics or material means lien that are recorded against the real property where the project takes place. Previously, one of my colleagues presented a video regarding liens generally in the state of Idaho, and specifically mentioned mechanics liens and material means liens. For information on the basics of mechanics liens or material means liens, I'd refer you to that video. This video is intended to be a companion or a follow-on to that video. While important for property owners, a recent change to Idaho's mechanics lien statutes is especially noteworthy for contractors, subcontractors, as well as rental equipment providers. These changes in Idaho law will and should likely require a change in practice, potentially in documentation, and certainly a renewed effort to ensure compliance with what is required to have a validly filed mechanics lien here in the state. Simply stated, a mechanics lien is a lien created under state law in favor of a person who furnishes labor or equipment to property. This lien is recorded against the real property in an effort to secure that person's right to payment for those services. It functions as a cloud on title. It essentially hinders the ability of the homeowner or the property owner to sell or otherwise use the property as they intend. That way, in a manner of speaking, creating leverage to ensure that at some point down the road, that contractor gets paid. Idaho law provides complex details pertaining to the scope, rights, and obligations, and ultimately the enforcement procedures of those mechanics liens. This video does not address each of those issues. Rather, due to the various issues affecting the rights and obligations of the mechanics liens, it's always advisable to work with a trusted attorney with the experience in these issues to ensure that you're complying. Nevertheless, it's been very commonplace, especially with the velocity of construction work in our area, for contractors to go it alone. Oftentimes, they use a form or a practice because it was used before and they effectuated that mechanics lien and ultimately got the desired result, which is to get payment. These professionals should beware. Among the various rules and requirements for filing a valid mechanics lien in Idaho, there was a recent and critical amendment to the Idaho mechanics lien statute that went into effect July 1st, 2022. There are three specific changes that a contractor should be aware of. There was a change in the text regarding who may provide personal service of a claim of lien on the homeowner. Previously, the statute set forth various methods of how notice of a lien should be provided to a homeowner. The statute had a general allowance to provide personal service on the homeowner with a copy of a claim of lien. Under the recent amendments, however, the legislature specified that such personal service of a claim of lien must be done by an authorized officer allowed or authorized under Idaho law to provide service. In other words, the amendment now requires a process server who is authorized under Idaho law to provide that kind of in-person service. There are certainly other forms of service that are valid under the statute, but in terms of personally serving the homeowner, that has been further clarified to include and limit that to officers allowed under Idaho law. The next amendment to Idaho's mechanics lien statute focuses on when a contemplated mechanics lien is being filed against residential real property. For purposes of background, the applicable statute lays out various types of requirements when a contractor, subcontractor, or other materials provider is filing a mechanics lien. Those requirements generally include some kind of statement or demand of the amount of money that is owed by offsetting any credits or payments that were made by the homeowner or the contracting party. You're required to name the property owner themselves, give a valid legal description capable of identification of the property where the materials were provided and where the lien is being recorded. And finally, you're required to include the name of the contracting person. If you're a subcontractor, it may be a general contractor. Under the amended statute, when work or materials to be provided fall within the type of construction projects that require a contractor's disclosure, typically most residential property projects, the construction professional filing the proposed mechanics lien must include in the claim of lien the required proof of disclosure and acknowledgement of receipt contemplated under Idaho law. However, simply put, the contractor entering into certain types of construction contracts is required to make certain disclosures specified in a statute and obtain acknowledgement from an owner that they received those disclosures whenever and before the contractor enters into a contract with the homeowner or the purchaser of a residential property. Under the amended requirements in the statute for filing a mechanics lien, that initial disclosure form and acknowledgement will now be required to be included with any newly filed mechanics lien on all applicable residential property. Again, these amendments went into effect on July 1st, and so all liens following that date are required to include evidence of those disclosures and the acknowledgement thereof. Although not stated in the statute, there may now arguably be new grounds ripe for challenging the validity of a mechanics lien. Those grounds could arise if the contractor never provided the necessary disclosures to the buyer before entering into the contract, or not obtaining an acknowledgement of receipt of those disclosures. Further, the mechanics lien could be invalidated if the required copy of those disclosures and acknowledgments are not included with the claim of lien being filed. This additional requirement illustrates the Idaho legislature's stated intent and renewed efforts to protect homeowners and purchasers of residential properties in the state of Idaho, and ensures that contractors are complying with the necessary disclosure requirements set forth under the rules. The third and final new amended provision in the mechanics lien statutes here in Idaho is of critical importance, and it deals with the issue of attorney's fees. Previously, attorney's fees were not expressly noted in the mechanics lien statute. Attorney's fees awards effectively functioned as a one-way street, where construction professionals could record liens with little fear of penalty for doing so in a sloppily or improper manner. Now the legislature has added an express provision to the mechanics lien statutes, providing for attorney fees to a prevailing party in any court proceeding regarding the filing of a mechanics lien. As should be evident, these new changes in Idaho's mechanics lien statutes are important to note. They impact all mechanics liens filed on real property here in the state of Idaho, and especially those residential real property. The consequences for doing so in an improper way without complying with the statute are significant. Failed compliance not only leads to a construction professional losing the right to place a lien on subject property, potentially, but it also creates the potential liability of incurring the expense of paying for attorney fees, not for only themselves, but also for the other party if they lose in a court proceeding. This underlines the importance of working with a trusted attorney to ensure you are complying with not only these new provisions, but all the provisions of the mechanics lien statutes here in the state. As always, you should consult with your attorney about your particular practices, your documentation, and any particular circumstances that you're facing. At Hansen St, our firm has the experience and the professionals to assist you with these and other legal matters.